Good afternoon, everybody. My name is Stephanie Hudson. I'm the Executive Director of Oklahoma Indian Legal Services, and I'm also the Vice President of the Oklahoma Indian Bar Association. This afternoon, we are pleased to present three speakers who will be discussing jurisdiction in Indian country post-McGirt. I think this will be an interesting presentation and will help answer some questions that people have had following this decision, Supreme Court decision. First off today, we have C. Stephen Hager. He has been an attorney at Oklahoma Indian Legal Services since 1990. And while at Oyles, he's been the author of 24 editions of the Oklahoma Indian Child Welfare Act Case Regulation and Analysis. He is also the Chief Judge for the Kickapoo Nation in Kansas and serves on the Supreme Court for the Kaw Nation of Oklahoma. He is a member of the Board of Directors of the National American Indian Court Judges Association and the Kansas Tribal State Judicial Committee. He is considered a well-known expert on Indian Child Welfare Act issues and will present us with some good information today about those types of issues post-McGirt. Steve?
Good morning, everyone, and I hope you're having a terrific Friday afternoon. I'm going to go ahead and I'm going to start with a quotation. I think when we talk about the Indian Child Welfare Act, it's always good to sort of remember how we came to the Indian Child Welfare Act. And perhaps the best way to remember that is to remember Richard H. Pratt. And Richard Pratt said the famous line to a committee of educators. He said, "A great general has said that the only good Indian is a dead one, and that a high sanction of his destruction has been an enormous factor in promoting Indian massacres. In a sense, I agree with the sentiment, but only in this, that all the Indian there is in the race should be dead. Kill the Indian in him and save the man." Now, that seems to be, a bit harsh for a bunch of teachers, but that is pretty much how people thought about involving Indians and Indian children. Richard Pratt, of course, was the executive director at the Carlisle Indian School, Carlisle Industrial Indian School in Carlisle, Pennsylvania. And he thought he was doing what was best. And the fact of the matter is that killing the Indian didn't change much through the entire 20th century. In 1974, an Association of American Indian Affairs showed 25 to 35% of all Indian children had been removed from their families and placed in foster, adoptive, or institutionalized care at some point in their life. The national adoption rate for Indian children was 8 times higher than for non-Indian children. 90% of those placements outside of Indian homes. In Oklahoma, 4 times as many Indian children were adopted or placed in foster care than non-Indian children. If you're wondering if that number's gotten better, not really. Indian children still make up about 1/3 of DHS removals from parents, despite Indians being about 17% of the state's population. So we see that, and then we remember that, the Indian Child Welfare Act was passed, and its whole point was to correct these conditions. Its whole point was to address them. We start with 1901, Section 1901, that talks about the special relationship between the tribes and the federal responsibility to Indian people. And it says that there is no resource more vital to the continued existence and integrity of Indian tribes than their children, and that the United States has a direct interest as trustee to protect Indian children. That an alarmingly high percentage of Indian families are broken up by the removal, often unwarranted, of their children from them by non-tribal public and private agencies. And that would certainly include the number of Oklahoma. Remember the statistics there. and that the states recognized, exercising their recognized jurisdiction over Indian child custody proceedings have often failed to recognize the essential tribal relations of Indian people and the cultural and social standards prevailing in Indian communities and families. For that reason, Congress developed the Indian Child Welfare Act to protect the best interests of Indian children and to promote the stability and security of Indian tribes and families. The whole point of ICWA was to make sure that Indian children remained with Indian families and remained with Indian tribes. So then we come to, 2020, the year of the pandemic, and we have a new Supreme Court decision, McGirt. And McGirt would appear initially to just be approaching the issues of, criminal jurisdiction, of whether or not the reservations of Oklahoma are intact. But when you say that the reservations of Oklahoma are intact, it goes way beyond criminal jurisdiction. It goes into the area of the Indian Child Welfare Act, 25 U.S.C. 1911A. And it is, and Lord knows if you've heard me speaking over the last couple of years, I've been yelling about this for a while now, and can't say that anybody's really particularly listened, but I'm still yelling about it. 1911A says in its entirety, an Indian tribe shall have jurisdiction exclusive as to any state over any child custody proceeding involving an Indian child who resides or is domiciled within the reservation of such tribe, except where such jurisdiction is otherwise vested in the state by existing federal law. Where an Indian child is a ward of the tribal court, an Indian tribe shall retain exclusive jurisdiction notwithstanding the residence or domicile of the child. So let's parse that, because this is something that is completely new in Oklahoma. ICWA's been around for 40 years now, and it's certainly not new in other states that have reservations. But here with McGirt, for the first time, Oklahoma has to address what is exclusive jurisdiction under the Indian Child Welfare Act. And this is going to be, I think, a really interesting time for us all to understand where we should be and where we're going to be with this language. Okay, the first thing that we need to remember in that 1911A is that the jurisdiction is exclusive as to any state over child custody proceedings. And as we're going to see in some of the workarounds that some of the tribes have tried to get together, it's going to be, I think, really questionable as to whether exclusivity can be waived. Jurisdiction is exclusive to the Indian tribe. And it's also, I think, important to remember that when ICWA was passed in 1978, there weren't very many Indian tribal courts. There were very few. This is a kind of a revolutionary law, and it's a very expansive law. Jurisdiction is exclusive to any state over any child custody proceeding. Now, there is some language there that says that it's an Indian child who resides or is domiciled within the reservation of such tribe. Okay, so you've got jurisdiction that's exclusive over an Indian child. Now that's important because sometimes, when we talk about Indian law and we talk about reservations, we talk about membership, and we talk about, you have to be a member of the tribe to gain certain advantages over that. ICWA doesn't have that language. ICWA says an Indian child who resides or is domiciled within the reservation of the tribe, that jurisdiction is going to be exclusive to the tribe. Okay, And then there's a third provision that is really necessary to remember and to understand. There's a provision that says, except where the jurisdiction is otherwise vested in the state by existing federal law. And of course, most people immediately think of PL 280 and the Kansas Act, other things that may provide for state jurisdiction over reservation lands. Now, most people aren't aware, but Oklahoma may have sort of a little tiny provision or exception for the 5 tribes in this situation. So we'll talk about that in a little bit. But generally, in Oklahoma, the issue of jurisdiction otherwise vested in the state by existing federal law is not going to be an issue that, tends to make me believe that the tribes have exclusive jurisdiction over any child residing on their reservations. So the question becomes, does McGirt just exist as to the Creek Nation? Does McGirt actually have a wider, broader approach? Well, as I think Arvo will talk about, the Oneida decision that just came out a few days ago out of the 7th Circuit, that would tend to indicate that McGirt is going to have a pretty wide, I think, a pretty wide impact. In that Oneida case, the 7th Circuit basically said that McGirt means that reservations have to be looked at and have to be regarded within the context of basically of congressional disestablishment only. So we have an interesting situation here in Oklahoma because, as I said, even though ICWA's been around for 40 plus years, we haven't really here in this state looked at it as 1911A jurisdiction. We have always looked at the issues as 1911B jurisdiction, which is concurrent jurisdiction or the issue of transfer. But the only children who have fallen under 1911A have been children who live on trust or restricted land. And, frankly, that's a relatively small number. So most of our Indian children have been placed in state court jurisdiction, in ICWA jurisdiction. Now, we have to ask ourselves some really serious and hard questions. Is it correct or is it proper for those children to be in state court at this point? And the answer probably is no, because 25 U.S.C. 1911A says the only courts that are going to have jurisdiction are going to be the tribal courts. So we have a situation here where we have a whole bunch of kids in state courts who probably can't be there, who probably shouldn't be there. And the answer, that most people, I think, the quick answer, the easy answer is, okay, so transfer them all over to the tribal courts. And with a lot of tribes, I don't think that's going to be a particularly serious problem. If you're a smaller tribe in Oklahoma, or if you're a tribe that has an effective court system, you're going to be able to accept transfer and address those children. The issue that has come about has been with the 5 tribes, which have a lot of people, a lot of members, and a lot of children in state court custody. So what we've seen happen there are some series, let me get forward here. What we've seen happen then is we've seen some agreements. They are called, let's see here, the August 7th agreement was called the Intergovernmental Agreement between the state of Oklahoma and each of the 5 tribes regarding jurisdiction over Indian children within each tribe's reservation. Now, the August 7th agreement, it should be noted, was only signed by the Chickasaw. There was an agreement on August 4th, an agreement between the state of Oklahoma and the Muskogee Creek Nation regarding jurisdiction over Indian children within the nation's reservation. Now, what these agreements, and I presented a paper, I've added a paper here to this, and so, wait a minute here. There is the paper is actually, let me get this called up here. The paper does have these agreements, these intergovernmental agreements attached to it. So let me get that called up. And when we kind of look at the agreements, it's really kind of an interesting attempt because it brings in an area of ICWA that frankly is just not addressed very much. 25 U.S.C. 1919. And what 25 U.S.C. 1919 says in its entirety is states and Indian tribes are authorized to enter into agreements with each other respecting care and custody of Indian children and jurisdiction over child custody proceedings, including agreements which may provide for the orderly transfer of jurisdiction on a case-by-case basis, and agreements which provide for concurrent jurisdiction between states and Indian tribes. Now, there's some language in 1919 that is, you know, fairly, I think, fairly broad, but there's other language in it that I think is fairly narrow in its structure. 1919 is not a particular provision that has been cited very much. It's not really something that has gone into the courts, and we don't have a whole lot of published opinions about it. There's a Nevada case called SMMD and TAD. The citation there is 272 Pacific 3rd 126. It's a 2012 case. And in this, the Nevada court upholds an agreement, and that agreement is between a tribe and the state that says the state can terminate parental rights, but a subsequent placement or adoption has to be completed in tribal court. So even if the parents are terminated, the child is still going to go through a tribal court process for placement or adoption. And that's the only case out of Nevada. There's a case out of Oregon, though, Matter of Kirk. And that's kind of a more interesting case, and it may actually have a little more connection to these intergovernmental agreements because it sort of looks at perhaps something that expanded the Indian Child Welfare Act a little bit. In Matter of Kirk, the Klamath tribe and the state had agreed to expand the definition of Indian child, and that would then include Klamath children who were of a lower blood quantum than the tribe required for membership. So you have children who are probably, you know, living on the reservation or close to the reservation. You have children who probably have close ties to the tribe, but they may not be qualified to be tribal members. The Oregon Supreme Court found that the state and tribe could not expand the clear language of the Act beyond the defined terms. 25 U.S.C. 1903 defines what an Indian child is, and in order to be an Indian child, you have to be a member or eligible for membership in a tribe. And what the Supreme Court said was that the language eligible for membership meant that a child whose blood quantum was insufficient to become a member, to become a citizen, could not be defined as an Indian child. And 1919 could not be used to expand that language. So we have a situation really in Kirk where the language is the language of the definitions of 1903 is crucial in determining if the state and the tribe could enter an agreement. Now remember, both the tribe and the state were okay with this. They both thought that this was a good solution to the problem of having Indian children who were almost members, but not quite. So we have that language. We have this language where ICWA has to control itself, and 19019 can't undo that requirement. Now, when we look at these intergovernmental agreements, and in particular the August 7th agreement, we have that same sort of situation. If you'll remember the language that I cited in 1911A, 1911A talks about exclusive jurisdiction, jurisdiction exclusive to the tribe. Well, what we have in the intergovernmental agreements is language that recognizes that, well, the exact language here is that the 5 tribes have exclusive jurisdiction over any child custody proceeding involving an Indian child domiciled within the boundaries of each tribe's respective reservation, as provided for in 25 U.S.C. 1911A. Okay, now that's in section 4 of the agreement. The language is very clear. The state recognizes that the tribe has exclusive jurisdiction. And, you know, I think it's really important to remember here that one of the big deals about McGirt is that to these agreements, the state is not saying we disavow reservation jurisdiction. The state is not saying, well, the jurisdiction is sort of reservation, but it's not precise. What the state and the tribe are entering into in these agreements is language that very clearly says that there is, in fact, a reservation and that the tribe has jurisdiction over that reservation. And so we have these agreements here that are perhaps best described as, you know, sovereign to sovereign. We have agreements here that say, without question, the state and the tribe are saying, this is how we're going to address these issues. So it's really, you know, it's a sovereign agreement. Now, you and I may disagree with the impact of this agreement. I may think this is a bad decision. I may not believe that it's appropriate for the tribes to enter into this agreement. But this is, by any stretch of the imagination, this is an agreement of sovereign to sovereign. This is an agreement that recognizes without question that the reservations are intact. And in that, you know, you've got to look at this agreement and say, well, good job, tribe, because you forced the state just in a matter of weeks to recognize that reservations in Oklahoma exist. It's going to be really hard for the tribe or for the state to come back in later after they've entered this agreement and say, well, we disagree with everything that we've said before in that. We don't recognize the reservation. So that's a good thing. The issue, I think, in the intergovernmental agreements are whether or not they can do what they did. And that is, I'm afraid, where I must respectfully disagree with the tribe and with the state here. And it comes down to the language that the Oregon court looked at in matter of Kirk. 25 U.S.C. 1911 says, that you can't go beyond the federal law in drafting a 1919 agreement. So when the state and the tribe enter into an agreement that basically does away with exclusive jurisdiction of the tribe, I just don't think that the language of 1911A permits that to go forward. The tribes have exclusive jurisdiction. As much as they may wish to share that jurisdiction with the state, short of a congressional action, I don't see how they can. Especially, and I think this goes, basically to civil rights, especially since 25 USC 1911A talks about the rights of Indian children, not just members, but it talks about Indian children who live within the reservation boundaries. You don't have to be a Creek child, for example, to live within the Creek Reservation. Under ICWA, however, the Creek Reservation is the only court system that has jurisdiction over you. It's not something that you can give away, I don't think, because it goes to a very basic, very significant level or ability to recognize the rights of someone who has a federal right under ICWA, and then to have that right given away by a political party that you may not have any way to control. So it's a 1911A jurisdiction, I think, is going to have to remain exclusive. And I don't think that a sovereign-to-sovereign agreement of these intergovernmental agreements can really apply to this situation. And there are some other factors in the intergovernmental agreement that I feel like also may well be a controlling factor here. If you'll recall, when we were talking about 1911A, I said, that there is a small connection here. Let me get back to the language of 1911A. Language, except where such jurisdiction is otherwise vested in the state by existing federal law. And there's actually kind of a little tiny vesting of jurisdiction within the state by existing federal law within the 5 tribes. And that is the Act of 1947. Now, most of you know that when we talk about restricted Indian land, we're talking about the 47 Act of the Stigler Amendments. And what that law says is that if a guardianship occurs, the law has to go to state courts, to state district courts for process. Okay, now, when this law was passed, there were 2 court systems in Oklahoma. There was kind of a state court system, a district court system, and there was the county court system, which was sort of like justices of the peace. And most of the outright thievery that was going on with restricted Indian land was, in fact, in the county courts. You had people there who were not required to be lawyers. They were justices of the peace. It was a political office. They were running for it. And what they were doing was, well, if you've read Killers of the Flower Moon, they talk a lot about the Osage land and how people were just basically stealing it. And at some point, somebody decided that the best way to steal the land was just to kill the people who own the land and then kind of trick them into their families and then take it. It's an amazing story. If you haven't read it. But the same thing was going on in restricted land in the 5 tribes. You know, you had people who would go to court, who would become guardians, and who would then steal the land from people. Often the people wouldn't even be aware that their land was being stolen. It would just happen. So the 47 Act says that you have to go to state district courts to get a guardianship. Well, that's 1947 and it's 2020 now, but that law has never really been addressed. It's never really been changed. So, you know, if you're doing a guardianship, you have to do it in state court. The tribal courts under 1911A would not have jurisdiction over it because the jurisdiction is vested in the state by existing federal law. So what does that mean in the 1919 agreements? Well, the 1919 agreements say that if a child lives on restricted land, that child custody proceedings, including things such as guardianships, would be done in tribal courts. But again, this is not something that the state and the tribe could really agree to, because under 1911A, jurisdiction is vested in the state by existing federal law. So if you're going to tribal courts to do that guardianship, there's a really serious question as to whether that guardianship is in fact enforceable, just as there's probably a really serious question as to whether or not a state court proceeding of a child living on the reservation is enforceable. So we have these issues coming up, and we have, you know, really, I think, significant concerns with these agreements. We have, there's some other issues here too. I've just been given my warning here, but there are some other issues too that talk about, you know, waivers and amendments and things like that within the agreement. But the termination of the agreement is very interesting, and it is that they can revoke by mutual consent by either the tribe or the state within 90 days written notice to the other parties. Now, this is kind of interesting because under 1919B, there's a 180-day revocation policy. So I'm not sure why they agreed to the 90 days notice. But the question will then become, you know, if you terminate the agreement, what happens to the children who are in state custody? Well, according to the intergovernmental agreement, what happens then is that the children will remain in state custody since their case has already begun there. And that's sort of an interesting approach, and it raises again serious questions as to the jurisdiction exclusive to the Indian tribe under 1911A. If the agreement has been revoked, I don't really quite understand how that revocation will not be automatically applied to any case that is within the system. So that's kind of a factor. Perhaps one of the more concerning issues is retroactivity. Under provision 10 of the agreement, the state and tribes agree that concurrent jurisdiction provisions of this agreement apply to any cases, actions, or proceedings pending at any time this agreement becomes effective. Now, that to me is sort of I don't know how effective that particular provision can be. I'm not sure the tribe can do that for cases that are already in state custody when they shouldn't have been in state custody. The tribe ratify and agree to extend full faith and credit to all child custody determinations. Well, again, I'm not sure how the tribe can enter into a full faith and credit agreement when jurisdiction is exclusive to the tribe. You know, you either have jurisdiction or you don't have jurisdiction. And I'm not quite sure how the tribe agreeing that you have jurisdiction when you don't have jurisdiction makes it any better. Furthermore, I'm not sure that parents of children who have been taken by the state would agree with that tribal waiver of the parental authority in this situation, and I'm not sure they could do that. So there are many things in these agreements that are really, I think, questionable and are probably going to require fairly serious and significant litigation to determine whether or not it's even appropriate to do that. Then we have the other tribes. And I would assume that if the state can get the 5 tribes to agree to these, they're going to be pushing other tribes to try to agree to them too. So you're going to have, and I'm assuming that some of the tribes are going to say, no, we just want our children, give them back. So you're going to have situations, I think, where in the pursuit of what I would call uniformity, the state is going to end up having to have wildly different rules for wildly different systems. And I think that eventually is going to become a bigger headache and a bigger issue, assuming that the agreements in fact remain in place. I think all of that's going to be a bigger headache and issue than if the state just said the tribe's reservations are intact and we have no jurisdiction over these children. So it's going to be an interesting time. I have described this previously, and I want you to all bear witness to me. I am going to finally retire this phrase. I have said in the past that if reservations are intact in Oklahoma, blood will run in the streets. And so, you know, with this agreement, with this proceeding today, I am not going to use that phrase anymore. What I am going to say instead is that there's going to be a lot of work for all of us to do to protect our children. Now, I've got to say that my take on the intergovernmental agreements is that sovereignty certainly gives the state and the tribe the right to consider these agreements, the right to create these agreements. I'm not sure that the law they're basing it on gives them the authority to do that. And so I think there's going to have to be a lot of work done and a lot of issues determined before these agreements can maintain in place. For the other tribes in the state of Oklahoma, they need to prepare their court systems. Their court systems need to be capable of taking in their children and of maintaining the ability to have all their reservation kids in their courts. And I have always been a major proponent of the court systems, the tribal court systems, doing that anyway. You know, the Department of Human Services is not one of the better Department of Human Services in the nation. And I've never really understood why Indian tribes have wanted to put their children in the tender mercies of DHS. We now have an opportunity to make sure that Indian children are protected, that Indian children are placed within the tribal family. And I think that it would be a really, really good thing if that's where McGirt led us to. So I see my time is up here. I think we're going to turn it over to Ms. Hudson and let her address the next proceeding. Thank you all for your time and your consideration.
Thank you so much, Steve. That was very informative, and I learned a lot today. The first thing I would like to do is take care of a little business. As part of the rules of the Oklahoma Bar Association, in order to receive CLE credit for the presentation today, you have to provide something that shows that you have been listening to the CLE today. So let me give everybody a couple of second warning and let you know that I'm going to read off the first word. And if you will send back all 3 words to the email address that was provided in the information, then we can make sure that your name gets submitted to receive credit for today's presentation. So today's first word is Tecumseh. So if you can provide that, that shows that you listened to the first part of the presentation today. Okay, so now to our next presenter. Our next presenter is Arvo Mikkonen. Arvo Mikkonen is an assistant U.S. attorney in the Office of the United States Attorney for the Western District of Oklahoma. He is a lecturer and a frequent instructor in federal criminal investigation, prosecution issues, and Indian affairs law. He has been a federal prosecutor since 1994. And he is also a former judge of the Court of Indian Offenses for the Anadarko area tribes. He formerly served as a justice of the Supreme Court of the Cheyenne and Arapaho tribes. In 2012, Arvo received the Attorney General's Award for Exceptional Service in Indian Country, which recognized extraordinary efforts by Department of employees who demonstrate a commitment to fight crime in Indian Country. Arvo received the award in recognition of his exceptional and long-standing efforts to enhance law enforcement response to crime. Arvo is an enrolled member of the Kiowa tribe in Oklahoma and is also of Comanche and Finnish descent. Thank you very much, Arvo.
All right, thank you very much, Stephanie. We're gonna go ahead. Can you go ahead and hear me now? Are you able to hear me? Okay. What I'd like to do is mention a couple things, and again, we want to welcome all the people that have joined in. We have over 250 people that have joined this CLE today, so we do appreciate your interest. Have been working with the Oklahoma Indian Bar Association since its founding back in the late 80s. We have a tremendous talented group of attorneys representing many different genres, many different places in our justice system, everything from judges to law clerks to law students and people that work in the government, also defense attorneys, prosecutors, just about everybody. So we're going to be sending out just a little bit more housekeeping. We're going to send out some email to everyone that had logged in today about how to join the OIBA. And we're going to be able to probably have further CLEs like this. And it's very important, I think, to those practitioners who are out there. Indian law, as I'm sure everybody has now experienced, is a very complicated and detailed area. The one good thing in terms of criminal jurisdiction is that a lot of people have been talking about there being confusion out in the public. Actually, since the Little Chief case in 1978, we've been handling Indian country crimes, and that started off in the Western District of Oklahoma, as many of you know, for over 40 years now. So the only thing that really has changed following McGirt is the area where these special laws apply. And I know that there are a lot of people that practice in Indian law, and then there's a lot of people that have decided to join our CLE who may not practice a lot in Indian law. It's very important, first of all, to understand the history, because if we look at what the Supreme Court has said in McGirt and all the other cases that were cited in McGirt, it doesn't make a whole lot of sense unless you look at almost 500 years of interaction between Native peoples and European powers. So I have prepared a CLE PowerPoint. We're going to provide you a copy of that PowerPoint ultimately, and we'll give you some instructions where that will be uploaded to. So I'm going to see if I can get this going here. I'm going to go through it quickly. Again, we're going to take questions at the end. So when we get to the conclusion of Casey Ross's presentation, we're going to address quite a few questions that I'm sure are going to come up rather than taking them in between here. And I'm going to go ahead and start this and see if hopefully we have it working. All right, looks like it's working well. Let's go ahead and start off. Why do we talk about criminal jurisdiction in Indian country? Of course, from the criminal perspective, and I have to do my standard disclaimer that when we go forward here and I present information, that is not the official position of the Department of Justice. It's not anything other than my own views, not really to be represented or considered to be an official position of the Department of Justice or the U.S. Attorney's Office. And again, I come from a criminal perspective, so there are tribal jurisdictions located throughout the country, as everybody knows, throughout the state. We know that people that choose to violate the law oftentimes will take advantage of that, not just between tribal governments and state governments, but sometimes it will also move from state to state and town to town to avoid detection. We really don't want that type of thing to happen when we have additional layer of criminal jurisdiction involving tribes. So that's why we have to work very closely, not only with our federal partners, but our state partners and tribal partners. Okay, this is where we start off with. They're the two cases that are the most significant in Indian law: Cherokee Nation versus Georgia, Worcester versus Georgia. Those are two cases where the U.S. Supreme Court ultimately decided that the Cherokee Nation was separate and apart from the state, separate and apart from the United States. The Cherokee Nation was a domestic dependent nation. The second thing is that as a domestic dependent nation, the general rule is, and this is where we start in all of our analysis, if the state does not have jurisdiction within Indian country, unless Congress has granted authority to a state over Indian country lands. Now in Oklahoma, as many of you know, we have many tribes now. Originally, we had the Kiowas, Comanches, Osage, Wichitas, Caddos, Delawares that were living here. Some tribes, such as my own tribe, the Kiowa, migrated to this area from Canada. Other tribes, such as the Comanches, came in from Wyoming, and it was not really by relocation as a result of any kind of treaties or government action, but is natural movement of some of the more mobile tribes. Now, most of us know about the 5 tribes, or sometimes referred to as the 5 civilized tribes, located in the southeastern part of the United States. As everyone knows about the Trail of Tears, again, each tribe has its own story. Each tribe has its own history. And so when we talk about the Trail of Tears, we often think of the 5 tribes, but there are many other tribes that were removed here to Oklahoma. During some of the negotiations, if you could call them that, the federal government in very explicit terms promised tribal nations that they would never be embraced in any territory or state This is an example from the Treaty of Dancing Rabbit Creek with the Choctaws. Another reference here is to the Treaty of New Echota with the Cherokees that said that essentially they would never be part of any state, never be part of any territory, and that they could govern themselves. And many of the treaties talked about a permanent home for the different tribes. Of course, if you look at Article 6 of the U.S. Constitution, it talks about treaties being the supreme law of the land. So notwithstanding the fact that the Cherokees won their case in the Supreme Court, or several cases, as most of us know, the Choctaws, Seminoles, Creeks, Chickasaws, and Cherokees were forced to remove to what was referred to as Indian Territory. Government policy was essentially to relocate or forcibly move different tribes. And initially the plan was for 2 giant reservations, one in the northern plains and one in the southern plains. And so once the tribes were relocated back in a stable area in Oklahoma, which was the Indian Territory, a lot of the tribes, as many know, established constitutions, had courts, had very complicated systems of law and education. Other tribes in the western part of the state, such as the Kiowas and Comanches, and this is a reference to the Treaty of Medicine Lodge, had a series of negotiations where they gave up certain areas of land. You can see here our original reservation was most of the Texas Panhandle and western Oklahoma. It was reduced to a smaller reservation in southwest Oklahoma. And you can see one of the quotes here from the one of the Kiowa chiefs, Setainte, who talked about making sure that the government would hold up to its word. Other tribes came here. I always like to ask the question when I'm instructing to law enforcement, you know, where did the Delaware tribe originate? And it's no trick question. Of course, they originated in Delaware. They probably have more treaties than any other group, having been moved from Pennsylvania to Ohio, Indiana, Missouri, Kansas, Texas, and ultimately to the Indian Territory. We also have tribes from the eastern part of the United States, such as the Seneca Cayugas, who came from New York, and the Modoc from the West Coast, who came in. And ultimately, there were over 70 tribes that were removed to Oklahoma, either by treaties or at basically military direction. So if you look at the maps of Oklahoma, and this is an example here, you have to really kind of look at what time we're talking about, because as time went forward, you can see more and more tribes were moved in from all over and assigned reservations either by executive order, treaties, or other congressional acts. So ultimately in 1889, we had somewhere around 40 or more tribes located in Oklahoma. And this is kind of a snapshot of what in 1889, when the Indian Territory was the entire Oklahoma except the Panhandle, how many tribes were located here and where they were located. Federal policy changed from recognizing tribal governments and dealing with them in connection through the treaty making process, and federal policy changed to attempt to forcibly assimilate or essentially break up tribes, break up tribal reservations, break up the land base. It was really a group of individuals that sometimes are referred to as what's called the Friends of the Indians. And what they did was essentially, after the abolitionist movement had secured the Emancipation Proclamation and the freedom for the slaves in the South, they decided to turn their interest to other groups, including Indians. And again, this is not really at the request of the Indians, but it was more a thought that, well, we need to help some other groups in our society, and let's help Indians. And of course, everybody wants to be a farmer, so let's promote this idea of adopting farming and homesteading among Indians, because that's what everybody in American society wanted at that point in time. Now, of course, that interest allied with other interests such as railroads and others who wanted to essentially get their hands at Indian lands, and ultimately did it through what's called the allotment process, which was opening of reservations. And this is where the question about reservation disestablishment or reservation boundaries, or what happens during this time frame from the 1880s forward to about the 1930s, that has created a lot of the confusion that we're now dealing with today. Of course, the promotion of people moving into these areas was really rampant. The railroads wanted people to move into the areas. And it was not just Oklahoma that this happened. Ultimately, most of you are from Oklahoma that are logged in here, but some of you may know about the unassigned lands, which are this shown in the red here. This is right about where Norman's located, up to Guthrie. That was the first area that originally was part of the Creek Nation and Seminole Nation that had not yet been assigned to any other tribes. There were actually plans to move Navajos out here, the Pueblos, a lot of other tribes that would have been put into this area had the Indian territory remained intact, as was promised in the treaties. So what happened, of course, we had tribal encampments, and then through various means, initially by what were called runs or land rushes, people came in and staked their claims either to those unassigned lands, or in many instances, tribal properties that were opened either by lottery or by runs. So if you start off with a reservation established by executive order or treaty or whatever congressional act, with the land runs coming in, prior to the land runs or prior to the reservation being open to non-Indian homesteading, assignments were made to tribal individuals living at the time. Now, of course, if you do the math, if you make the pieces of the allotment small enough, then there's going to be a lot of leftover land. And that was exactly what happened, at least with respect to a lot of the tribes in Oklahoma. So if you assign one of these parcels to an individual Indian, breaking up the entire tribal area and now assigning it to an individual Indian, if you make the pieces small enough, then there's going to be these leftover areas, and that's the leftover area that were subject to entry by homesteaders. It also created different categories of land, because some of the land was reserved for tribal use, like cemeteries. Some of the lands were reserved for government use. An example of that is like a dependent Indian community such as Riverside Indian School, that we now recognize in the Western District as being a dependent Indian community. So now we have this checkerboard situation. For example, with the Kiowas and Comanches and Apaches, that's the area that I'm most familiar with. We have this original 3 million acre reservation, which was the result of the Medicine Lodge Treaty. And then notwithstanding the fact that there was fraud that took place, there was, and this is well documented, and most of you that have any knowledge about Indian law know about the Lone Wolf case, which said that the U.S. Supreme Court upheld the ability of Congress to abrogate or violate a treaty. The violation there was they did not get 3/4 of the adult males to agree to the opening of the reservation as was required under the treaty. So because the pieces of the allotments were made so small, what happened to the reservation essentially transformed it from one large block of land to all of these small squares, which are the red areas now, which were the allotments that were made. Sometimes when a reservation was opened up, it also included reserved areas such as these grazing lands. This was called the Big Pasture. You can see Fort Sill Military Reservation. So it depended on what tribe, the individual situation, how the land got opened up, and whether or not there were remains of tribal lands inside of the treaty boundaries or whether or not the entire area was heavily homesteaded. So the situation in Oklahoma is not unique. You can see, look down here at the Pine Ridge Reservation. This area of Rosebud was open, and you can see all the scattered allotments which are outside of the boundaries. Same thing with Pine Ridge here. This is the Palm Springs Reservation in California, which is actually superimposed over the city of Palm Springs, and it is a perfect checkerboard. This is what the Cherokee Nation looked like after allotment. The Lakotas, and a lot of these Supreme Court cases that were analyzed in McGirt involved reservations up north. Rosebud Sioux versus Knipe involved this reservation. Dakota versus District Court involved that reservation. The Solemn versus Bartlett case involved these reservations here. And this is actually what Pine Ridge looks like if you were to look at the land status, notwithstanding the fact if you look at Rand McNally, it looks like one large square, but this is actually what it looks like. Fort Berthold, very similar situation, and it is also heavily allotted here, tribal land, Indian-owned land, non-Indian homesteaded land, which we generally refer as fee land, and these areas in here that are not filled in are actually the fee land areas that were homesteaded by non-Indians. Cheyenne River Sioux Reservation, same thing. So it's highly unusual for a reservation to have one contiguous block of land that's owned by the tribe, unless it was out in a desert area like the Navajo Reservation and people weren't clamoring to acquire it. Okay, so this understanding all of that going on leads us to determine jurisdiction, because when you have these this change of land status, it causes issues with respect to who has jurisdiction where. Of course, under federal law, Title 18 U.S. Code Section 1151 is what we look at to determine what is tribal and what is federal jurisdiction as opposed to what is state jurisdiction. And this is a criminal statute. The case law that's very consistent is that the criminal definition of what is Indian country also applies in the civil context. So when you decide what is criminally Indian country, that also has implications for civil jurisdiction. So what is, just so that we all know, what does Indian country include? It includes 1151A, all lands within a reservation. It also includes rights of way going through the reservation, whether or not they're interstate highways or small county roads. We have what are called dependent Indian communities, and there's a special test for that under the Venati case in the Supreme Court and the Adair case in the 10th Circuit. And then the bulk of what we have in Oklahoma, and we had since day one after statehood, was restricted allotments on the eastern side of the state and trust allotments on the western side of the state. I often ask people, even before McGirt, are there Indian reservations in Oklahoma? And I do a lot of training to law enforcement, and the question oftentimes is, no one will raise their hands one way or another. If I were to charge somebody with committing a federal crime, let's say at Riverwind Casino or the Hard Rock Casino, I would reference in the indictment 18 U.S. Code Section 1151A, a reservation, because an allotment is owned by individuals, and 1151B is not really applicable as a dependent Indian community. So all casinos are 1151A, most tribal headquarters are 1151A, offices which are owned by the tribe as a government are 1151A. So technically, are there reservations in Oklahoma? I would have said yes, even before the Supreme Court said yes as well. In this case, Oklahoma Tax Commission versus Chickasaw Nation talks about the concept of an informal reservation. And Indian Country USA also says that formal designation of Indian lands as a reservation is not required for them to have Indian country status. So there's really two kinds of reservations that you can have, which are either tribal trust lands still held in trust, or the original reservations that were set up by treaty, executive order, or other congressional act, the large contiguous blocks. Again, most of the allotments in Oklahoma, both trust allotments and restricted allotments, even notwithstanding the fact, if you open up Cohen's Handbook, I did this the other day, open up Cohen's Handbook of Federal Indian Law and looked at what the definition of Indian country was, and to see whether or not restricted fee allotments were included. It's obvious that restricted fee allotments are Indian country, and that was in 1942. That determination was made, yet it's not until the 1990s that we have other cases that have said that Indian country does include restricted allotments. Here's a map inside the city limits of Lawton, which shows tribal trust lands here, also shows allotments. That's the Comanche Casino, Fort Sill Apache Casino. And so you can see when we have jurisdiction without boundaries, we have to determine whether or not this 1151C location is where the crime took place. If it took place over in this area, then we don't have jurisdiction federally or tribally. The federal government wouldn't have jurisdiction over that. But if it happened on one of the colored squares, then it would. And this is tribal land, which is shown in the green. Now, it's important to look at why McGirt led to the result of the boundaries being so important. And sometimes people talk about disestablishment of a reservation or diminishment of a reservation. I always like to talk about it, whether or not the boundaries exist or not, because it's a little bit easier to understand. So the language from the Indian Country Statute in 1948 clarified that Indian country includes all lands within a reservation, notwithstanding the issuance of any patent. And what that means is it doesn't matter if it's the non-Indian owned land here, or if it's a trust or restricted allotment there, or tribal land here, the entire area is Indian country. So essentially what happened prior to McGirt in Oklahoma with the Creek Nation, we had scattered allotments and tribal trust lands. And then with the boundaries, the entire area becomes Indian country. We may talk about civil jurisdiction in the third portion of this, and I'm sure there'll be some questions about that. One of the big areas of litigation right now, and it's not as clear as criminal jurisdiction, is what is the authority of a tribe within Indian country, within the reservation boundaries, over these fee lands that are owned by non-Indians. So if we look at the McGirt case, I'm sure probably everyone has read it. If you haven't read it, I would definitely urge you to read it. It's been surprising to me that some people have actually not read the case and are talking quite a bit about it. It's important to look here, and looks like there was a mistake here on the way that this saved, but essentially the concepts here are that once a reservation is established, only Congress can diminish or disestablish it. It requires clear congressional intent. And so when you go back and look at what Congress did, you have to look at the original act, and there's a three-part test that comes from approximately 10 different cases, starting out with Matz versus Arnett, Dakota versus District Court, Solemn versus Bartlett, Rosebud Sioux Tribe versus Knipe. And in most of those cases, the issue is whether or not those boundaries around the reservation were still there after allotment. There was originally some thought that once a reservation is allotted, then it loses its boundaries. The cases clearly show that that's not really the case. Now in Oklahoma, when we look at the situation of the different tribes here, and ultimately how McGirt was decided, there was nothing said in connection with the allotment of the Creek Nation, and by extension, the other tribes the other 5 tribes with respect to what's happening with the boundaries. Actually, in most of the allotment agreements, with a couple of exceptions, the reservation boundaries are not addressed. And that is part of the problem that we've had in Oklahoma from day one, is everyone has assumed things, has assumed that the boundaries are gone, or assumed that the tribes have lost their power to have jurisdiction, assumed that there's something different about the western part of the state from the eastern part of the state. There have been a lot of assumptions over the past century with respect to Indian country and whether or not the boundaries of the tribe still exist. And that's what essentially was addressed in the McGirt holding, was that we first looked to the acts of Congress. Now, if you look at the acts of Congress with reservations in Oklahoma, you'll see very clearly with respect to 2 reservations, the Otoe Missouri tribe and the Ponca reservation, when they were opened and allotted, it was very clear that Congress said, okay, the boundaries are erased. They're abolished. They're attached to Kay and Noble counties, so it's absolutely clear there. And what has happened in McGirt and a lot of these other cases is the courts have tried to struggle and figure out what was congressional intent. Now the strange thing about it, and if you go through and read the cases, oftentimes the court is looking at a variety of different factors. Sometimes they look whether or not the tribe consented to the allotment. Sometimes they look and see whether or not how the land was opened, if it was agreed upon, how much per acre was going to be provided, how much, whether or not the entire reservation was opened or not. So for each tribe, it's going to be necessary to go through and look at those agreements, look at what was negotiated, and examine whether or not there was clear congressional intent. Now, it's somewhat strange, and I think if you look at, if the question is congressional intent, and you look at, well, population figures at the time or population figures now, or for example, in the Dakota versus District Court case, they're citing newspaper articles from the 1890s as to what congressional intent was by interviewing tribal people. It's just a very, very unusual and strange kind of method of ascertaining congressional intent. And that's why we have cases all over the place. And I think that's led to the confusion that we have here in Oklahoma, that finally the Supreme Court has clarified that if Congress doesn't act, if there's no act that essentially opens the reservation and eliminates the boundaries or erases the boundaries, then the question of whether or not those boundaries survive allotment is a question. And almost every reservation, again, with the exception of some of the very remote desert reservations, were opened and allotted. So the fact that they're allotted doesn't necessarily answer the question. So that's essentially why we are where we are today. The other thing is there's a general perception or a theory or as it's covered in the press, that this decision only applies to the 5 tribes. Now, the other 5 tribes are most similar to the Creeks, but there were other cases pending in front of the Supreme Court that were also remanded after McGirt, and those included criminal cases coming from the Seminole jurisdiction, the Choctaw Nation, the Ottawa, and the Citizen Potawatomi. And as Steve had referenced earlier, again, nothing really in McGirt turns on its application only to the 5 tribes. If you read McGirt, it really is trying to make sense out of all of these disestablishment opinions that have been pronounced by the court since the 60s. Now, as many of you know, and you're probably why you're on this seminar, is we have many different courts trying to figure out, okay, now what do we do? Does it apply to the Choctaws? Does it apply to the Chickasaws? Does it apply to these other tribes? And we have here's a copy of an opinion that was filed on May 5th from LaFleur County that said the Choctaw Nation boundaries continue to exist. And I know that there are other opinions out there that say the boundaries have been disestablished. So this is probably the first thing to do, is to allay the assumption, again, another assumption, that this opinion only deals with the 5 tribes. I've been saying this for quite some time, and a couple weeks ago, July 30th, the 7th Circuit, relying upon McGirt, upheld the boundaries of the Oneida Nation, which is, as you can see here, is right next to Green Bay, Wisconsin. So each one of the tribes in Oklahoma, perhaps with the exception of the Oto, Missouri, and the Ponca, and actually I even hate to say that because I haven't analyzed that and I'm not expressing an official opinion of any kind, are going to have to be analyzed to determine their own histories, what happened during the allotment acts, what provisions were applicable, how the land was opened, all types of questions. So whether or not there are continuing reservations for the other tribes is going to be a case-by-case basis as determined by litigation. So really, again, the bottom line is the only thing that changed in the law was where is Indian country. And so now Indian country, at least for the Creek Nation, includes the original, all the land within the original boundaries. The other thing that we need to determine in order to figure out jurisdiction, who is an Indian. Now that's pretty simple to figure out. Again, here's a population of, showing Oklahoma obviously has got a high population of Indians. Every tribe has its own definition of membership and how to join, what blood is required. The federal courts require a 2-part test, and you have to have some Indian blood or recognition by a government entity that you are an Indian. So that can either be tribal enrollment, or it could be perhaps be recognition by the federal government for special services that are set aside exclusively for Indians. ICWA, that's the Indian Child Welfare Act, has a particular provision under federal law that allows somebody to be considered to be an Indian, such as a child, if they are capable of being enrolled, because a lot of times children are not enrolled. Sometimes tribal member families let a child get to the age of majority, 18, to pick what tribe they want to belong to if they have more than one. The other thing is that we've seen, again, in trying to determine who's Indian and who is not. A lot of people say, well, if you've got an Indian card, what is an Indian card? Well, we need to clarify that, because the fact that somebody has Indian blood, again, doesn't mean that they're a member of a tribe. You could have Indian blood or a CDIB, and perhaps if you're not enough of what the tribe requires, you would not be recognized as an Indian. So for example, this one relates to Cherokee, but if this was 3/16 Kiowa, I can tell you right now, you could not be enrolled because the Kiowas require 1/4 blood. The better thing to look for in determining jurisdiction is tribal membership, particularly one, for example, here that indicates a degree of blood. And so that would be proof that that person is considered to be an Indian under federal law for jurisdictional purposes. So the other thing that we have to figure out is what type of crime is involved in order to figure out jurisdiction. Generally, in 1978, Indian tribes' jurisdiction changed after a Supreme Court case called Oliphant. And Oliphant's, the U.S. Supreme Court case, came down from a reservation in Seattle that said that Indian tribes do not have jurisdiction over a non-Indian. So tribes only have jurisdiction over Indians. Now that's changed a little bit, and I'll explain what happened in 2013, which gave or recognized tribal jurisdiction over non-Indians for a certain class of cases. But generally, tribes handle misdemeanors, and jurisdiction is over Indians with the exception of domestic violence cases. Now, we talked about the Little Chief case a little bit. That was a case that came up in 1978. Procedurally, what happened there, it was on an Indian allotment. There was a major crime, a murder, Indian versus Indian, clearly federal jurisdiction under the Indian country definition. A case was filed in Caddo County by the district attorney's office. It ended up in the Court of Criminal Appeals. The Court of Criminal Appeals waited until the Western District of Oklahoma made a determination that the crime pursuant to an indictment was indeed federal jurisdiction. And that happened in 1978, and that's when the so-called CFR courts, or courts of Indian offenses, were reestablished in Western Oklahoma. Ultimately, after other litigation took place in the 80s and 90s, similar holdings were made with respect to the restricted allotments in the eastern part of the state, and CFR courts and tribal courts were established there. The code for offenses that are relied upon in tribal courts include either a tribal code or the CFR code, and it is all offenses committed by Indians generally, Indian victimless crimes, Indian versus non-Indian crimes, and Indian versus Indian crimes that are misdemeanors. Now remember, when we talked about the Cherokee cases stand for the principle that the state has no jurisdiction in Indian country unless Congress permits it. Now, there is an exception here, and that involves a non-Indian versus non-Indian crime. And that came up in a Supreme Court case that came out of Colorado, where a non-Indian murdered another non-Indian on the Ute Reservation. And in U.S. versus McBratney, the Supreme Court said, well, since there were no Indians involved and it was an Indian reservation, and federal superintendents and obligations and trust responsibility really is directed primarily to dealing with Indians and Indian property, we're going to recognize a essentially judicially created exception to the rule being that a state does not have criminal jurisdiction or any civil jurisdiction in Indian country unless Congress so allows it. So then the question has come up, does this exception, the McBratney exception, which is essentially a judicially created recognition of state jurisdiction in Indian country in the criminal context, does that apply to non-Indian versus Indian crime? The answer to that question is no. There haven't been cases that have held that. Certain states elsewhere in the nation have utilized a federal statute called Public Law 280 to obtain that jurisdiction, not just jurisdiction over non-Indian versus Indian crime, but Indian versus Indian crime and Indian versus non-Indian crime under the Major Crimes Act, which is 18 U.S. Code 1152 and 1153. And actually, state courts that have looked at this question, is there state jurisdiction when there is an Indian victim or Indian property involved? And the answer has been no. These are cases out of South Dakota, Arizona, Montana, North Dakota, and these are state court, either Supreme Court or appellate courts that have said, no, the state does not have jurisdiction over a non-Indian versus Indian crime. So the rule is, for criminal jurisdiction, the state has authority over non-Indian versus non-Indian crime or a non-Indian victimless crime. So when there's an Indian involved, then there is federal exclusive jurisdiction, particularly if it's an Indian victim. Okay. And actually that law that was a precursor to 1152 came before what's commonly referred to as the Major Crimes Act. The Major Crimes Act resulted after a homicide on one of the Sioux reservations, and the tribe punished it pursuant to tribal law, which was essentially kind of like a wrongful death. The victim's family was compensated by the offenders and the offender's family, and Congress saw fit to say that's not appropriate. We're going to extend federal court jurisdiction over certain major crimes. Now, those major crimes have been expanded over the years. Generally in federal court, we get into federal court basically two broad ways, either because something happens on Indian land or federal land, or because it involves interstate commerce or a federal interest. Now, when we talk about the Indian Country Crimes Act or the Major Crimes Act, it's also referred to as the General Crimes Act. again, 1152 or 1153, those are based upon the location of the offense. So that's when we have the Indian country land definition that comes into play to give us jurisdiction in federal court. These are a list of some of the major crimes. Actually, it's not an exhaustive list, but it's most of the crimes. We have what are called felonies under Chapter 109A. Those include many, many different types of sexual abuse offenses. Sometimes we don't have a federal law definition for certain crimes such as burglary or incest or felony child abuse, and we have to rely upon assimilating state law or incorporating state law for those elements of those crimes. Again, what was at issue prior to the McBratney case and prior to the passage of the Major Crimes Act was what's referred to as the General Crimes Act. And essentially what that did, and that goes back very, very early into the years of the foundation of the Republic, where Congress essentially said, we're going to treat Indian lands like a federal enclave, like an army base, and we're going to exercise jurisdiction over a wide variety of offenses, everything in the federal code, essentially, not just the major crimes. Now, the General Crimes Act has certain exceptions, probably too detailed to go through here, but crimes Indians against Indians, and this is important to look at in the context of Public Law 280, because if you look at the language of Public Law 280 that gave the state's jurisdiction within Indian country, it talks about crimes by or against Indians. So crimes by Indians would have been crimes under 1153. Crimes against Indians would have been crimes under 1152. So that's further support for the position that if Congress is giving the states jurisdiction under Public Law 280, that goes against the concept that they had jurisdiction originally under Public Law 280. Let me see how I'm doing on time here. Our timekeeper, if you could send me a text message when I'm to that point. I think I'm getting there pretty quickly. I'm going to jump ahead a little bit. So again, we still have jurisdiction in Indian country, not just because we have jurisdiction over federal Indian lands, federal or Indian lands. We also have jurisdiction when it involves either interstate commerce crossing state lines, like our gun cases. When we prosecute a gun case in Oklahoma, all gun manufacturers, major manufacturers, are located outside of Oklahoma with a few narrow exceptions. So when we have a gun that's in this district, in the Western District, for example, or in the Eastern or Northern District, it had to have crossed state lines, traveled to interstate commerce, and that's our federal hook to get into federal court. There's a couple of special statutes that I wanted to bring to your attention, and they're unusual in the fact that they don't really rely upon Indian land, and they don't really get as much analysis or recognition as sometimes we do these other major crimes. And these are some crimes that, including habitual domestic violence, and that's like a third strike. You have 2 prior domestic violence offenses. If you're within Indian country, we can prosecute you federally if you have 2 priors, and that can be a tribal court prosecution or a state court prosecution. Failing to register as a sex offender is also a federal crime if you're in Indian country and you fail to register as a sex offender. So this is a summary of essentially what I've gone over. Victim crimes, again, the tribe is going to primarily prosecute Indians, Indian versus non-Indian, and Indian versus Indian. If there's no Indians involved in the crime, then you're going to deal exclusively with state and local authorities. Federal courts have jurisdiction when we have Indian versus a non-Indian, and that would be a Major Crimes Act crime, or an Indian versus Indian, only the Major Crimes Act crime under 1153, or a non-Indian versus Indian. Victimless crimes, again, if there's no Indians involved, that remains under state jurisdiction. Over Indians, both the tribe and the federal government can prosecute victimless crimes. I'll just mention VAWA, the Violence Against Women Act. We get a lot of questions about that from time to time. That's primarily based upon interstate commerce, so there always has to be crossing into or out of between state boundaries. Interestingly, VAWA also allows for passage between state and between Indian country lines. So we can have a VAWA case if we have interstate commerce, essentially between state jurisdiction and tribal jurisdiction. Also, we're going to be providing a copy of this PowerPoint, and we're going to email instructions where you can download it. You will be able to take a look at this later on. One thing that I wanted to note under TLOA, remember I mentioned that tribes really had misdemeanor penalties. TLOA, which is the Tribal Law and Order Act, extended that to allow tribes essentially to prosecute felony offenses for a total of up to 9 years or 3 years per count. In addition, I mentioned the special jurisdiction, which was recognized pursuant to VAWA, the Violence Against Women Act, and it's what's called the special DV criminal jurisdiction. And that allows for criminal jurisdiction by a tribal court over non-Indians. In other words, a tribe can have a tribal code and prosecute non-Indians. However, the non-Indian has to have sufficient ties to the tribe or reside in the community or have some kind of connection to the jurisdiction that they're located in. So somebody just coming down the interstate who happens to say commit a domestic violence type offense while at a casino probably wouldn't be covered by that. And what it includes are domestic violence, dating violence, and violation of protection orders. And again, these are some of the defenses that a defendant can raise if they are charged with an offense like that. Some of you may have seen this chart that I've compiled over the years. If you want a copy of it, go to the just Google U.S. Attorney's Office, Western District of Oklahoma. It is on our website. And this essentially is a 2-page chart which summarizes essentially everything that I've said and would answer any kind of question about jurisdiction that you might have. The first page deals with an Indian offender, and it shows if you have an Indian offender, there's a definition of an Indian. What are the major crimes that are included? It goes to federal court or to tribal court. If it's an Indian versus a non-Indian, all the federal major crimes plus the additional crimes pursuant to 1152, which allows us to charge additional crimes. And again, the tribe can prosecute its own crimes. Victimless crimes we described. The special crimes that I mentioned, this habitual domestic violence, failure to register, are listed here. And then always remember that we still have federal jurisdiction by virtue of interstate commerce or a federal interest. The second page of the chart shows a non-Indian offender commits a crime against an Indian. Again, that's exclusive federal. Or a non-Indian offender commits an offense that is within this special DV domestic violence jurisdiction. The tribe can prosecute a non-Indian versus an Indian offender here. Non-Indian, again, no Indians involved, that's state alone. And the same thing here, victimless crime, no Indians involved, then that would be state jurisdiction only. We can probably address some of these things in the questions, but I do want to just touch very quickly on a couple of things. How do we deal with the practical considerations? Now we have at least the Creek Nation, perhaps other areas are going to be recognized as reservations. How do we deal with that? Again, law enforcement has been handling these types of issues for over 40 years now. Cross-deputization is very important, and that's where we have both state, federal, tribal authority for our officers, so they don't have to figure out what side of the line they are. I've heard stories from law enforcement will say, well, I can't tell if somebody's Indian or not. Of course, you can't tell if somebody's an illegal alien or not. You can't tell if they're a felon and can't possess a gun or not without further investigation. You can't tell if somebody has a domestic violence protection order applicable against them. So the fact that you can't tell if somebody's Indian or not is just another part of investigating a crime. There are some new mapping programs. If anybody's interested in that, we have an app now that you can download to any phone where you can pull up every allotment in the state and zoom in on it, kind of using Google Earth. I just found out about that this past week. I'm going to further investigate how we can allow more people to handle that. We have a federal misdemeanor court to handle certain crimes in the Western District, which is called the Central Violation Bureau. And we now have additional resources for murdered and missing Indigenous persons. I've talked with several, we have reports from law enforcement saying, well, how do we run a car tag if it's a tribal car tag? Some of the tribes, I believe the ones that have compacts with the state, such as the Cherokee Nation and the Chickasaw Nation, perhaps others, if you're running OLETs, if you see a tribal tag, it would certainly make sense to have the tribes either provide that information to law enforcement so we can track car tags like we would any other car tag from any other jurisdiction. Right now, a lot of the tribes are ramping up their enrollment capabilities. So if somebody is trying to determine if somebody is enrolled or not, to figure out which court that they should go to. I know that the Chickasaw Nation and the Cherokee Nation now have their 24-hour dispatch able to determine if somebody's enrolled or not, if we have accurate information about their name. So we'll leave questions to the last part of it, and I will go ahead and thank everybody for the attention that you provided. Certainly, I'm sure that a lot of you will have additional questions, and I'd be glad to answer those, and you can contact me at the U.S. Attorney's Office or through the Oklahoma Indian Bar Association to address those. Thank you.
Thank you, Arvo. I appreciate all the information. We've got a number of questions from people, and at the end of this, we'll be sure and provide time to ask questions. Let's go ahead and take care of a little bit of housekeeping. I'm going to go ahead and provide the second word. I'll go ahead and say it twice this time to make sure everybody hears it. The second word is Sequoia. In order to get your CLE credit, the second word is Sequoia. Okay. The Oklahoma Indian Bar Association wants to thank the American Indian Law and Sovereignty Center for co-hosting this event. We were able to gain the CLE credit. We were able to make sure that we could put on this program today because of support from the center. And I'd like to introduce Casey Ross. Casey Ross is the University General Counsel for Oklahoma City University. She also serves as the clinical professor and the director of the American Indian Law and Sovereignty Center at Oklahoma City University School of Law. There, she oversees the American Indian Law program, teaching clinical and doctrinal courses in tribal law, American Indian wills and probate, Indian gaming law, and federal Indian law. She's also serves as module faculty for the Native American Enterprise Management Certificate Program, a joint collaboration between the Chickasaw Nation and the Minder School of Business at Oklahoma City University. Prior to joining faculty at Oklahoma City University School of Law, Professor Ross served as the Senior Legislative Counsel for the Cherokee Nation. Casey is also the founder of an all-Native female-owned consulting firm, Advocates for Native Issues. Her firm provides consulting services to tribes, tribal organizations, and other stakeholders with an interest in Indian country policy. The firm works on training, curricula development, Indian health law and policy, and self-governance advisement. Professor Ross is a citizen of the Cherokee Nation. Thank you very much, Casey.
Good afternoon. Thank you for that introduction, Stephanie. Thanks so much to the Oklahoma Indian Bar Association for allowing Oklahoma City University School of Law to co-host this session with you. I appreciate all of you taking the time on a Friday afternoon to hear from the speakers on this important topic. My remarks might be a little bit more brief than my co-presenters, but I want to leave plenty of time for questions and answers since we have so many participants today. Before I begin my remarks, I want to start off with just a couple of disclaimers. First, none of the views that I'm going to express today necessarily reflect the views of my employer, Oklahoma City University. And none of my comments necessarily reflect the views of my co-panelists who have already presented here today. Next, I also want to acknowledge that my comments are those of a law professor coming at this topic from an academician lens. And I have not participated in any of the underlying litigation in Murphy or McGirt other than signing on to an amicus brief as a legal historian. But the work of countless American Indian law practitioners really drove us to where we are today. And I want to give credit to that effort by clearly communicating that I contributed very little along that way. The work of Patty Palmer-Gezzi started us all on this path in Murphy, and she is the first and best expert to talk about the framing of the legal arguments that were ultimately successful. I don't currently represent any clients with causes of action that are impacted by the decisions, and I have not been at the table for any of the discussions that have occurred between the tribes, the state, and federal representatives. So I'm going to try to keep my comments in my lane, which is as a casual observer looking at these issues from the perspective of a professor who trains future lawyers. So I'd like to start off today by just going through a list of questions that I've frequently seen. They really come to us as a result of the McGirt decision. Many of you have already been fielding these questions, and while it's important that we have answers, it's equally important to understand how the questions originated. It's not any surprise that there are many industries in Oklahoma and individuals in Oklahoma who do not favor the exercise of tribal sovereignty here. All you have to do is look at the list of amicus briefs that were filed in favor of the state's arguments in both Murphy and McGirt to see these embedded constructs that originate in anti-tribal and frankly, in some ways, very racist ideas about Oklahoma Indian country. So throughout the last few years, as these cases have been working their way through the judicial process, there have been a lot of narratives that I call those Chicken Little narratives that really took hold in public discourse. And I really, kind of categorize these things as scare tactics, but because they have actually impacted the public's view of the issues, I think it's important. So I think it's really important for us to effectively as possible communicate the sky is not falling. The sky is absolutely not falling. So I'm going to talk through just a few of kind of the bigger ticket items that I've seen in that discourse, just to kind of communicate to you how I'm handling those questions when I've been getting them. So first, I've seen a lot of questions about what the impact is of the McGirt decision on other tribes. And I agree with my co-presenters that it's not just an automatic application to every other tribe in Oklahoma, and for that matter, every other tribe in the United States. So in McGirt and before that in Murphy, we saw that the court wanted to look through an exhaustive analysis of all congressional action that pertains to a specific tribal reservation. The 10th Circuit opinion in Murphy, if you haven't read it, I encourage you to go take a look at it. But it goes through a really painstaking analysis of all the congressional acts that dealt with Muskogee Creek Nation's reservation. And the same exact process, the same exact level of analysis is going to be required for each individual reservation in Oklahoma to determine if that particular tribe's reservation was ever diminished or disestablished. So obviously the remaining 4 of the 5 tribes have the most similar allotment histories to the Muskogee Creek Nation. So I'd imagine that the analysis exercise yields a similar result for the Cherokee, Chickasaw, Seminole, and Choctaw Nation reservations. As for other tribes in Oklahoma, that same painstaking analysis needs to be conducted to determine whether there was congressional action that disestablished those tribal reservations. I'd like to also mention that McGirt is not only applicable to Oklahoma. Courts outside of our state, as Steve Hager mentioned, have already been using McGirt to analyze reservation claims for other tribes in other states. So McGirt has a lot more breadth in its application than just Oklahoma or just Muskogee Creek Nation. Another item that I saw pretty frequently as Murphy and McGirt were making their way through the judicial process was this alarmist claim that if the court made a decision in favor of tribal jurisdiction, somehow the tribes in Oklahoma would, quote, own all of the property in the state of Oklahoma. I saw that on Facebook. It's probably not a great idea to get any kind of information off of the Facebook, but that's where I saw it the first time. So yeah, you see this discourse going back and forth about how the tribes are going to own the entire state of Oklahoma. But I want to just, make it clear, and I've had to answer this question a few different times, that the McGirt decision does not change property ownership inside of the reservation. So when we're thinking in terms of an individual who owns a parcel of property inside of a reservation, that individual's property ownership interest is not going to be impacted as a result of McGirt. I'll also just briefly mention that the decision doesn't affect the real property tax rules in the state of Oklahoma. Non-Indian fee land still going to be subject to state real property taxation, even inside of the reservation. One of the bigger items that I've seen a little bit of confusion on going back and forth as a result of the McGirt decision, and Arvo pointed out that there would be some discussion in my presentation about this issue, is the impact McGirt has on civil jurisdiction in Indian country. So I've gotten a whole lot of questions about this. The decision in no way impacts the construct of civil jurisdiction rules that apply, the ones we all learned in law school. But I want to talk a little bit later about the future of those rules and how they may change. So in law school classes, when we teach civil jurisdiction, we look at adjudicatory jurisdiction, we look at regulatory jurisdiction, but we really spend several weeks looking at all of the civil jurisdiction cases that have been decided. And those of you who took Indian law in law school will remember spending a good 4 or 5 weeks on civil jurisdiction. You will remember studying for it and preparing for your final exam. You will remember that as you prepared for your final exam, you didn't really know exactly what the best answer was going to be when the fact pattern was presented to you, and that's entirely normal because frankly, civil jurisdiction is a mess, right? The way that the Supreme Court has handled civil jurisdiction issues in Indian country has resulted in kind of a mess. So we have to work our way through this mess of Supreme Court opinions, and when we analyze them together, we see the rules that apply for purposes of civil jurisdiction. Interestingly, when you look at those early cases where the court was looking at civil jurisdiction in Indian country, you see the court itself conflating terms, using Indian and non-Indian interchangeably with member and non-member. We practitioners have learned those terms are not equivalent to one another, and the court's gotten better at it over the years to stop conflating those terms, but it really has resulted in a lot of confusion about the rules of civil jurisdiction. So in addition to looking at the member, non-member distinctions, we also have to pay particular attention to the status of the property where a cause of action arises for civil jurisdiction inside of Indian country. It's a totally different set of rules than criminal jurisdiction, right? So Arvo went through criminal jurisdiction with you, and we're thinking in terms of you're either inside the reservation boundary or you're not, right? For criminal jurisdiction, the question is, are you inside the reservation boundary or not? For civil jurisdiction, you really have to pay particular attention to the status of the particular parcel of land where a cause of action arises. So when we work our way through these Supreme Court decisions, we start to see the court seeming to put together one rule for civil jurisdiction for causes of action that arise on trust or restricted property, and then another set of rules that apply for causes of action that arise on fee land inside of a reservation. So after we spend all of our time and our analytical power on weeding through these decisions, one thing is clear, okay? The court has told us in its own unclear ways that tribes have more civil authority over their members than they do over non-members. So think about that. When we look at the reality of fee land ownership within Muskogee Creek Nation's reservation, we've got to remind ourselves that folks on fee land, when we're talking about individuals who are on fee land, the Supreme Court's told us that tribes have more limited authority over non-members on fee land, okay? So remember back to law school, remember back to when you took Indian law and you had to learn about that Montana case, right? That Montana case that set forth this general rule that tribal courts don't have civil jurisdiction over non-members for conduct on fee land. unless that non-member has entered into a consensual relationship with the tribe or its members, or the non-member's conduct threatens the political integrity, economic security, or health and welfare of the tribe. So that Montana case gives us a general rule with these exceptions that might allow a tribal court to exercise jurisdiction over a non-member for a cause of action that arises on fee land. So since Montana, the court has really narrowed the exercise over non-members on fee land even more by specifying the type of effect it's looking for. So when the court looks to make a determination under that second Montana exception, the court has really limited those instances that might have an impact on the tribe's political integrity, economic security, or health and welfare to those matters that are necessary to protect tribal self-government and control internal relations. So when you look at these civil jurisdiction cases, you start to see them put together, and those exceptions just get more narrowly and more narrowly applied. So each civil jurisdiction case the court looks at has just further limited tribal sovereignty and tribal authority over non-members. So it's not cool, right? It's not cool. The cases get more confusing and they get more out there as we've gone along. So you'll recall the last time the Supreme Court had occasion to sound off on civil jurisdiction was in that Dollar General case a few years ago. Now I'm just going to tell y'all, I was terrified when that case went up, because I really recognized that the case was going to require the court to look back at this mess of civil jurisdiction that has been created. And I feared that as the court was comprised at the time, and also based on how the court looked at civil jurisdiction cases immediately preceding Dollar General, that the court would gut their own precedent and come up with something brand new that even further limited tribal authority. And when I say it outside of the context of Indian law, people look at me like I'm crazy. Like, you know, the Supreme Court, they care about their precedent. They're going to follow their precedent. But we Indian law practitioners have seen plenty of times the expected outcome that we thought we would see from the Supreme Court somehow is a totally different thing. It's like apples and moon rocks. You can't even compare the two, right? So at the time Dollar General was decided, the court did stick with its own precedent on civil jurisdiction and left in place that mess of rules that we all had to learn in law school. But that might not always be the case. And we'll talk about that a little bit more in just a little bit. So I want us to, as we remind ourselves of what these rules offer civil jurisdiction in Indian country, I want us to remind ourselves that McGirt doesn't change those rules. The rules are still there. McGirt doesn't change them at all. But I also want us to be thoughtful and remind ourselves where that construct originated, right? So you'll remember Oliphant, right? Remember the Oliphant case. Now that was a criminal jurisdiction case, but it really did set forth kind of the Supreme Court's reasons why tribal courts weren't going to be treated the same as other courts, right? And when you look at the civil jurisdiction cases, they're citing Oliphant left and right, even though that's a criminal jurisdiction case. But Oliphant really began that standard where you see the court saying things like, you know, it's not fair to subject someone who's not a member of the tribe to the tribe's law and customs. It's also not fair for non-members because they don't get to vote in tribal elections, so they don't have a voice in the laws of the tribe. And you start to see that get just brought up and used in future cases to basically result in a situation where the Supreme Court is limiting a tribal court's authority to hold non-members accountable. So all those concepts really come to us from an unfair double standard that's not applied to determine the civil authority of other sovereigns. It's just been imposed on the tribal courts, and in my academic opinion, improperly so. I also want to mention that this overriding fear of tribal court jurisdiction is confounding to me. Tribal courts are absolutely competent courts. So while the forum might feel somewhat different, tribal courts are entirely capable of administering justice, and they should not be recognized or thought of as inferior courts. I really resist the idea that we as Indian law practitioners are in a position to soften the concerns of folks who are afraid to litigate in tribal court. I just want to tell people, try it out, go to tribal court. Tribal court's great. nobody needs to be afraid to go there. You're going to get a fair shake. Tribal courts are absolutely competent and can administer cases in justice. So to wrap up my comments on civil jurisdiction, McGirt hasn't changed any of the rules that apply to the exercise of tribal civil jurisdiction. And right or wrong, the Supreme Court has limited the exercise of tribal civil jurisdiction over non-members in many, if not most cases. So I've also seen quite a bit of traffic in the discourse related to environmental regulation. And I want to just remind us that back in 2005, Senator Inhofe attached a midnight rider to the transportation bill that was moving through Congress at the time. And what that rider does is it requires Oklahoma tribes to come to an agreement with the state prior to exercising treatment as state authority under EPA structure. And that rider also sets the path for the state to exercise state regulatory authority in Oklahoma Indian Country. I don't at all like that rider, and I don't at all agree with the idea behind it, but I just want to put it out there that it happened, and that prior to McGirt, there had already been some congressional intrusion into the tribal exercise of authority, particularly as it relates to environmental concerns here in the state. I saw a lot of traffic about Indian child welfare in these weird Facebook posts, and I'd get, emails from former students. And I think Steve's already done a really good job presenting his thoughts on the impact of the decision, the McGirt decision on Indian child welfare. I think he's also, disposed of the unwarranted concerns that were utilized as scare tactics as they relate to Indian children. If you want to see an example of kind of the scare tactic approach that I'm talking about, I encourage you to listen to the audio from the Supreme Court argument in Murphy. The attorney, Lisa Blatt, I don't know her, I've not met her, but she kind of uses her summary time to talk through these concerns as they relate to Indian child welfare. And I've had a chance to visit with Steve about those before today, and we both agree that those were largely overstated and not reality. So Steve's done a really good job of highlighting a lot of the Indian child welfare issues. Arvo's done a great job presenting his thoughts about the impact of the decision on criminal jurisdiction. I agree with Arvo 100% that McGirt does nothing to change the rules of criminal jurisdiction in Indian Country. These are the same rules that we learned in law school. They're the same rules we've been teaching forever and ever. The rules have not changed, but the decision will result in a shift of criminal cases away from the state and towards the tribal courts and or the federal courts. So various sovereigns having authority in Indian Country is not new. It's business as usual in many other reservation-based states, and it's business as usual even here in Oklahoma. Even before McGirt, tribes, the state, and the feds have always followed these rules for criminal jurisdiction, albeit now, post-McGirt, the land-based recognition will result in those cases being handled differently and shifting from one sovereign to another. So tribal courts definitely need the time and the ability to stand up more robust resources to buttress their infrastructure and manage an increased caseload, but these cases are not new. Now there are just going to be more of them in tribal court that were previously incorrectly tried in state court. Now, from a law enforcement perspective, it's also important to remind ourselves that cross-deputization agreements are already operating in Oklahoma Indian Country. These agreements allow tribes and local law enforcement agencies to respond to criminal activity, regardless of whether the crime occurs on Indian land or non-Indian land. These agreements are very successful in addressing personnel needs, but also allow agencies to leverage and synergize resources to best respond to criminal activity. These agreements are already in place and can certainly be expanded and strengthened to address law enforcement needs in Oklahoma Indian Country. So to wrap up this first section, I'll just say that many of the sky is falling items that were floated out into the public discourse are full of sound and fury signifying nothing. Continued work under existing law and in furtherance of cooperative agreements can address a lot of the concerns that are actually real, and we need to really clearly and effectively communicate to folks when those kind of sky is falling narratives rear their ugly heads. So I want to spend just a little bit of time. I want to switch gears and talk a little bit about the path forward, because there's been a lot of noise since McGirt about the efforts to address concerns that are presented as a result of the case. The first public announcement came from the 7 members of the Oklahoma delegation. It was on the day of the decision, actually, where those folks promised to work to affirm tribal sovereignty and ensure safety and justice for all Oklahomans. They released a little press release, a joint press release among the 7 Oklahoma delegation. So shortly after, the state attorney general released an agreement in principle that set forth some aspects of post-McGirt planning. Tribes that have been involved in those discussions that led up to the release of the agreement are taking time to review that proposal internally within their own tribal government and in consultation with their own constituents. I've seen at least a couple of the tribes have put together their own commissions to take a look at the impact of McGirt for their own individual tribal communities. So that thoughtful work as a result of the McGirt decision continues at the tribal level as well. So again, I want to be fair and I want to be very clear. I have not been at the table in any of these discussions, as tribal leaders have been meeting with the state attorney general on these matters. But I do understand that when you're in a position of leadership, sometimes you have to know things that all of your constituents don't know or can't know. So I'm sure the tribal leaders are working through assessing the threats to sovereignty that have become more focused after the decision. Again, look back at those amicus briefs that were filed in support of the state in Murphy and McGirt, and it'll give you a preview of the counter arguments that are no doubt presenting challenges and momentum for a potentially harmful outcome through adverse legislation. As Steve mentioned, the use of cooperative agreements, whether temporary or permanent, entered into between the tribes and the state can go a long way towards addressing concerns that arise as a result of the decision. But they have to be explored with a critical eye for maintaining the robust exercise of tribal sovereignty for the long haul. Now, as Arvo mentioned, in criminal jurisdiction, there's a need for training, planning, resource, execution, to address the shift in cases that will no longer be tried by the state and will now be properly tried by the tribes and or the feds. So while I fully understand that there are threats out there, I want us as Indian law practitioners to also be thoughtful about the opportunities that this case presents. So during the 15 years I've spent teaching future lawyers, I have spent just about every semester teaching federal Indian law, warning my students in federal Indian law of the risks that are just inherent in taking a case up to the Supreme Court. My generation and most generations before me have read the Indian law cases since Cherokee Nation versus Georgia, and we've seen how warped the jurisprudence has been on the whole in each new case. For the past several years, the court seemed to be outwardly hostile to Indian interests. Think about Nevada versus Hicks. Think about Plains Commerce Bank. As a result of the court's composition at that time, Indian law practitioners have had to be really protective and also creative, also, seeking remedies outside of the judicial system just to best protect tribal interests. But to quote Justice Gorsuch, today is a new day, right? Justice Gorsuch has seemingly switched what used to be a 5-4 majority against Indian interests to a 5-4 majority that's willing to look at the body of Indian law the way we have always taught that it should be. And not just in McGirt. Take some time to read Gorsuch's concurrence in the Yakima Treaty case from Washington State. That concurrence is a thing of beauty. I encourage you to read it. Those of you who haven't had a chance to read McGirt yet, please do so. Excellent writing and just really, really good slam dunk. But it demonstrates to me that Gorsuch is providing leadership to other justices on the court as it relates to these issues. And let's remind ourselves, Justice Gorsuch came to the Supreme Court from the 10th Circuit, and the 10th Circuit had occasion to look at a whole lot of Indian law. So he comes to the court with an understanding of Indian law issues that his other fellow justices just haven't had. The very first Native person ever was hired as a Supreme Court clerk, and she's a member of the Chickasaw Nation. So in many ways, Indian law under the court's current composition is better than it's ever been, at least during my career. So the current court presents an opportunity for further development of federal Indian law jurisprudence that is as it should have always been, protective of tribal interests under the supreme law of the land. One portion of the agreement in principle that gives me pause based on the comments I've made here today is the section on civil jurisdiction. It's for those reasons I've already stated. Because the court's composition presents this opportunity, it's important for us to examine the agreement in principle or any kind of agreement or proposed statutory language. Any of that really needs to be looked at with a critical eye. Because the court's composition presents this new opportunity to have Indian law cases addressed in a way that actually recognizes what Indian law has always told us it's seeking to do, we really need to look at all these things carefully. We need to be really careful not to codify something just because it's the way the rule works right now. Things may change with the new court, and from the perspective of someone who's been hoping the court would get it right at some point, now with its current composition, it just might. So none of my comments are meant to ignore the fact that tribal leadership is currently weighing all of these competing interests, the threat of potentially harmful legislation that occurs without their input, balanced against the future opportunity to seek remedies by Supreme Court review. So I've been asked a few times for my unofficial opinion on the best path forward for addressing the issues that we have already been discussing today. Again, keep it in mind, I do not have a seat at the table as these things are being discussed, and I shouldn't. I'm an academic. So this is just, my unofficial and academic opinion as to the best path forward. As a general matter, I do not believe congressional statutes are necessary to work this through. The only congressional intervention I support is a federal appropriations bill that provides funding for the strengthening of tribal courts and tribal infrastructure in recognition of the fact that tribes have been working for centuries to undo harmful federal policies that have really been aimed at weakening tribal sovereignty. Despite these significant intrusions, we're still here and we're up for the challenge of implementing the decision in a meaningful way that protects the integrity of tribal sovereignty. So as we move forward, my advice would be to methodically assess what is needed to best protect sovereignty moving forward into the next 100 years. This case presents a real opportunity for us here in Oklahoma, the tribal leadership here, the Indian law practitioners here, to be super thoughtful about how we want this to unfold over the next 100 years. It's a really, really important case. I have heard concerns from tribal members, tribal citizens, friends of mine all over Oklahoma Indian country that, implementing a lot of these practices is expensive. It's extremely expensive to develop the types of infrastructure improvements that are going to be needed to implement this decision in the best way. And again, I would just put a plug in for the idea that it's really important for us to have an eye towards our next 100 years and to take potential expenses into account and maybe amortize those over a good 100 years. So thanks so much to all of you for your time and your attention today. It's not always easy to get together on a Friday afternoon, particularly as people are trying to get themselves ready for the weekend. But I now want to turn this over to Stephanie Hudson. She's going to work with her staff to assist with the question and answer segment of the presentation. So thank you all for your attention.
Thank you, Casey. I appreciate that. We have Case Rodwell with us today, and she has been monitoring the questions that have been in the chat and in the question and answer box. So we're going to go ahead and let Case ask the questions and let the speakers go ahead and answer the questions. Thank you, Case.
Thank you, Stephanie. I'm going to try to get to the questions as they came in order, so I apologize if I have jumped over one or looking over one. Just know that I'm getting to your question. I believe the first question we had came for Steve. They were asking what was the name of the New Mexico case that you cited during your presentation?
There wasn't a New Mexico case. There was a Nevada case. Hang on just a second, and I will call that case up if I can get into the file here. Now there are two cases really that kind of apply in this situation under 1919, and the one out of Nevada is called SMMD and TAD, and the citation for that case is 272 Pacific 3rd 126. It's a 2012 case from Nevada. The other case is Matter of Kirk, you know, live long and prosper, and that's 11 Pacific 3rd 701. It's a 2000 case out of Oregon.
Okay. Well, and the next question we had was also for Steve during your presentation. They wanted to know, in your expert knowledge, does Seminole Nation have an agreement with the state of Oklahoma pursuant to Section 1919?
Not that I'm aware of. Arvo might actually know that, and Casey might also be aware. I am not aware of anything from the Seminoles at this point.
I believe the first agreement was with the Creek Nation, and then I saw that the Cherokee Nation also had an agreement. I believe the Choctaws have as well, and that's the only ones that I'm aware of right now. Again, it's kind of a fast-moving, every day there's something happening. And for those of you that don't know, those agreements are uploaded on the website of the state Secretary of State for the state of Oklahoma. So if you want to look at them, you certainly can do that by going to the state's website. And also all of the cross-deputization agreements, other agreements, tobacco compacts, other things are all found on the state Secretary of State's website.
Okay, our next question is for all the panelists. This one references 25 USC 1911A jurisdiction. Their question is 1911A jurisdiction is subject matter jurisdiction, and I agree that it can't be waived. What do you all think?
Well, that's, yeah, I don't think you can, the problem with the agreements in my mind is that it's exclusive jurisdiction, and that's the same issue that was really raised in Kirk. You can't use the provisions of 1919 to avoid the clear and present language of the Indian Child Welfare Act. There isn't any reason to believe that the court would, in one provision, say you have exclusive jurisdiction, and then in another provision let you waive that exclusive jurisdiction without saying it in 1911. There is also language within ICWA that talks about, well, that addresses approaches within the state to expand jurisdiction, and that would be oh Lord, I can't remember what that was. I think it's 1921. Yes, 1921 says that the state can provide a higher standard of protection than the rights of ICWA, but the state can't provide a lower standard of protection under 1921. So you have provisions that the state can do under the Indian Child Welfare Act, but there's no indication that the state can, you know, take away an Indian child's rights under the Act, and that's really what these agreements do. You know, the whole point of ICWA, the whole point of 1901 and 1902 is that they're saying that Indian children should be in tribal courts, that tribal courts are a better place for them to be. And these acts, I understand why the tribe wants to do them. I just don't think they can. So that's kind of my position. You know, opinions may vary.
Okay. Our next question is, what does McGirt mean for the ability of local law enforcement agencies to respond to and investigate crimes committed within these reservation areas?
Well, a couple things, you know, that come into play. Again, we have all kinds of overlapping and sometimes what might be perceived as conflicting jurisdictions. Ultimately, what happens, you know, for example, I live in Norman and I live in Cleveland County. If I were to go across from one side of town to the other, I might be in the jurisdiction of the sheriff's office. I might be in the jurisdiction of the city of Norman. If I'm on a highway, I might be under the jurisdiction of the highway patrol. If I went on the OU campus, I might be within the jurisdiction of the OU campus police. If there was a federal crime, there's an FBI office not less than about half a mile from my house. So there might be FBI type crimes. So we have this, and this is just not unique to Indian country. So we have this everywhere. So really what we want to do, and it's just not, again, related to tribal jurisdiction. Now, tribal jurisdiction, at least within the boundaries of the Creek Nation, is included among the group of authorities that can respond to crime. So these are the things that we think about. Number one, communication, making sure that tribal officers and state officers and federal officers and county officers can communicate with one another. The other thing is information sharing. Sharing information such as, you know, the enrollment records I've mentioned, car tags, things that might not be otherwise easily accessible to state and local officers. And then finally, cross-deputization. And a lot of people don't understand that. Sadly, we don't have as much cross-deputization as we should. And what does that mean? Well, a law enforcement officer should be able to be a law enforcement officer and not worry, am I on the right side of the line or am I on the wrong side of the line? Am I going to be dealing with an Indian person or a non-Indian person? You can't figure those things out when you respond to crime. That's part of the investigation. Again, and I mentioned that sometimes people say, well, there's a tribal tag. Maybe they're Indians in the car. Well, that's not necessarily true. You don't really know. You have to investigate and find that out. So really developing partnerships is extremely important. Sharing information, developing partnership, cross-deputizing. I was involved, and this is the thing, again, it was shifting resources. So the other thing that I mentioned to people, and you know, we don't have more crime. The crime is going to stay the same, really. And if you think of crime as a threat to our public safety, which it is, if you think about it like a fire. So if we're fighting a fire and we have one team fighting the fire, so now, at least in those areas where Indian country is included, we might have three teams. We have a state team, we have a tribal team, and we have a federal team. And we're all working together for a common goal of protecting the public, vindicating the rights of victims, and also making sure that defendants who are charged have their rights, their constitutional rights protected under the U.S. Constitution or the tribal constitutions. A lot of people forget about that. The tribes have their own constitutions and constitutional rights. And, you know, the very good thing we have here in Oklahoma with respect to tribal law enforcement and tribal courts is all the tribal courts here are filled with law-trained attorneys, prosecutors, public defenders, people that one day they're in tribal court, the next day they're in federal court, the next day they're in state court. And that is something that I think those of us who are Indian law practitioners are very proud of. So I hope that touches on some of those issues that were raised by that question.
Thank you, Arvo. Is there a list anywhere in the federal statutes of specifically what misdemeanor cases would be covered?
Well, again, it depends. So what we do generally, and actually it's interesting because there is one misdemeanor in the Major Crimes Act, which is kind of a misnomer. There's an assault against a child under 16, which is a Major Crimes Act misdemeanor. But if you were to look at the federal code, yes, there is a list of offenses in the federal code which would be considered to be misdemeanors. The federal code is about that thick. And the way, and I referenced it, I did have a lot to get through there, but federal law also sometimes will enforce tribal law and sometimes will enforce state law. So if we don't have a federal law covering something, for example, like I said, burglary, then we borrow or assimilate state law and make state law applicable to Indian country. So yes, there is, you would look at the federal code first. If it's not covered by the federal code, then you may go to the state code. And like for hunting and fishing regulations, oftentimes we will look to it to make sure if somebody's charged federally with violating hunting and fishing, they have to comply not only with state law, but tribal law.
Great. We have two questions that were kind of similar, so I'm going to do maybe like a compound question. What is the effect of McGirt on juvenile delinquency proceedings? And is there any reason that the issues of McGirt would not apply to juveniles in delinquent cases?
So you're talking about juveniles who have committed crimes? Well, a lot of people don't know this. We do handle juveniles in federal court, and anybody who commits what would categorically be defined as a crime in federal court, who is under the age of 18 at the time the offense took place, would be treated as a juvenile. And we have very special procedures for dealing with juveniles. They're all confidential. They are not including the right to a jury trial unless they have a right to a trial before a judge, unless they want to be treated as an adult. But the juvenile cases go through the federal court system very similar as a regular criminal case. Now, ultimately, a juvenile would not be found guilty of a crime. They would be adjudicated as a juvenile delinquent, which is actually kind of a civil status. If they were sentenced to serve time, then they would go to the Bureau of Prisons, much like any other federal defendant, and the Bureau of Prisons has contracts with juvenile facilities, so they would be treated in a similar way that they would in state court.
Great. How do pleas work in Major Crimes Act cases? Can defendants plead to lesser offenses that the federal court would not otherwise have jurisdiction over?
Generally, when we engage in plea negotiations, and I think most people that practice in criminal law know, both in the state system and the tribal system and the federal system, that most cases are resolved by pleas. Literally, you cannot have, there's just almost not enough time for prosecutors and judges to have every case go to trial. So what we look at are usually what the circumstances are, their criminal history, what the type of offense was, have this person committed this crime before, whether or not we would engage in plea agreements. Sometimes there's cooperation, where one defendant will provide information about other matters outside of the scope of what they've been charged with. Generally, if we have a plea to a federal charge, then, and we wanted to allow a plea to a lesser charge, it would have to be another lesser federal charge. We really can't allow somebody to plead guilty to a state crime that they wouldn't otherwise be subject to being charged with in the first instance.
Great. We have another question that I believe is an ICWA question. They ask, what about a tribal child and a non-Indian parent? So panelists, can we discuss when ICWA applies when one of the parents is non-Indian?
Well, ICWA applies in the same fashion. The status of the Indian Child Welfare Act is being the parent of an Indian child, not being an Indian parent. So in that situation, if you were an Indian child and you were a non-Indian parent of an Indian child, ICWA would apply. And that would mean that under 1911A, if you lived within the reservation boundaries, your case would be within the exclusive jurisdiction of the state. I hope that answers it. But yeah, the status of the parents is not the significant status. It's the status of the Indian child. Great.
How will McGirt affect the legal cannabis industry in Oklahoma when a first offense simple possession marijuana charge is a felony under Muskogee Creek Nation Tribal Code?
Ooh.
Well, of course, each jurisdiction has the right to decide what are considered to be crimes in their jurisdiction. So the Creek Nation has the right to decide what is legal and illegal behavior, as does the federal government, as does the state government. So again, the Creek Nations, again, to be under the jurisdiction of the Creek Nation, they would have to be within the Creek Nation's Indian country, which would be anywhere within the boundaries. And then the individual involved would have to be an Indian. So they would have to have tribal blood and be enrolled or recognized by either the federal government or tribal government. And if they decided to make certain things illegal, then that would be up to the right of the tribe to do that.
Great.
Just say no to drugs, kids.
When a person is charged in federal court, would we need to object to any convictions that previously occurred wrongly under state jurisdiction? And would they need to go post-conviction?
I'm not sure I understand the question. Could you read it again?
Yes, I can. It says, when a person is charged in federal court, would we need to object to any convictions that were previously occurred wrongly under state jurisdiction? And would they need to undergo post-conviction?
Well, if somebody's charged in federal court with a crime, then whatever happened in the other crime really doesn't matter. I mean, generally when somebody is arraigned, we can charge somebody either by what's called a complaint, where we have an affidavit and we have a law enforcement officer swear that those facts are correct. The judge finds probable cause, issues a warrant, and then they're charged. We have 30 days to either indict the individual, or we can file what's called an information. But what happened in other cases prior to that time really have nothing to do with us proceeding with the federal charges. Now, where it could come into play would be perhaps if they were sentenced. And I saw this happen, and this is public record. I saw this happen in a case I just had a sentencing on, and it was either Monday or Tuesday. And this individual, and the way the federal court system works is very different from the state court. So when somebody's charged and they either found guilty or they plead guilty, we have what are called sentencing guidelines, okay? And the sentencing guidelines are a very complicated set of factors that are considered. What happens is there's a pre-sentence report, and the probation office does an investigation regarding exactly what happened during the crime, and looks at their prior convictions, and it's a point system. So what happens is, depending upon, let's say we had a bank robbery. So the sentence ultimately would be calculated based upon how much money they took, whether or not they used a gun, Did they possess a gun? Did they brandish a gun, which means they waved it around, or did they shoot the gun? So you go through all these different factors and you come up with a number. And then that number is correlated in a chart in the sentencing guidelines that will come up with a range of punishment. Now, if somebody pleads guilty generally, they will be entitled to what's called acceptance of responsibility. They may have some points deducted. So if they plead guilty rather than going to trial, they may get either 2 or 3 points off. And it comes up with a certain offense level. And then depending on their criminal history, they're either categorized as a criminal history category 1, 2, 3, 4, 5, or 6. So what happened in the case I had recently, and happens quite often, is they may say, well, you know, judge, you know, yeah, they were convicted of a felony, but now it's a misdemeanor. And we had, that comes up from time to time and came up recently. So you really shouldn't count it as severely as it appears on paper. Tribal court judgments aren't counted at all, which is kind of interesting. As military court judgments do not contribute to the criminal history category unless the judge decides to apply them. In other words, so if you have multiple prior tribal convictions, they're not counted at all. They don't bump your criminal history category up. So sometimes they can argue, the defense attorney can argue that, like they were doing in this case, that you're counting these felonies. It's not really a felony now under Oklahoma law, so you should give it less weight. We might come into court as prosecutors and say, all these tribal convictions, we have multiple assaults, and they aren't counted at all. And so the court should consider that in determining a sentence. And again, the sentencing guidelines are not mandatory. The judge can go either above or below. It's called a departure or a variance. So it's generally kind of a range of punishment that the judge generally will stay in and has to justify either going above or below. And that's the other thing for defense attorneys. In the federal system, there is no parole. And everybody has to do 85% of the time that they're sentenced to. So, you know, just as a matter of course, you know, any defense attorney needs to be familiar with the sentencing guidelines before you start advising your clients whether or not to bring up issues one way or not, one way or another. You may end up with more time in federal court, or, I mean, that's just part of calculating out what the impact on your client ultimately will be.
Thank you. How will the acquisition of rights of way work on fee land within the boundaries of a reservation? Will it follow the BIA guidance that was updated several years ago, or will it follow the state's current acquisition process for fee land?
I saw that question in the chat box, and I don't know if my other co-presenters have a good answer. But honestly, I don't have a good answer to that question. I would look to other states with reservation-based communities interspersed with non-Indian fee land that's owned inside of the reservation boundary to see how the BIA process is utilized in those instances. But I'm really not familiar with how other states are handling that issue.
I feel like I should say that I don't have a clue. I just don't. But, you know, like Casey says, this is new for us, but it's not new for the rest of the world. You know, the states that have reservations have processes, so we can actually look and see how that works. I have no idea.
I'm not certain about that either. Now, I do know even in areas, certain counties, you know, and this has worked out well for Oklahoma communities. You know, I was driving around down in southwestern Oklahoma and saw that the Comanche tribe has access to federal highway dollars and has put in bridges, has put in new roads in some very rural areas, which are not very good. And so that again goes to the idea that, you know, we all live here together. You know, there's all these overlapping jurisdictions, and the fact that, you know, the tribe now has, reservation boundaries, or the tribes continue to exist, period, without reservation boundaries, generally, in most instances, helps everybody. I mean, everybody's driving down that road. It's just not a road, just that Indian people use.
Thank you. Our next question is, Oklahoma Attorney General Hunter said the reason for state and tribal agreements was that tribes don't have the bandwidth to handle the number of Indian children. Is this so?
Well, I'm going to let I'll just say in general, we live in a time of paranoia and a certain amount of, shall we say, QAnonism. And that can't help but to bleed over, I guess, into myself. When someone who has just finished litigating against you suddenly wants to tell you how difficult it's going to be for you, I have a natural tendency to say, prove that. And, the other thing that I think is really important to remember about, especially the Indian Child Welfare Act, is that there are a lot of cases involving Indian children. Many of those cases probably didn't need to be in state court in the first place. That's why the numbers are so stunning. When you're 17% of the state's population, and yet you're 33% of the cases that are in state courts, something is wrong there. Now, it may be that all of those cases are needed, and if that's the case, the tribal courts are going to need to be able to address those cases. But a lot of those cases, I feel, and this is, based on 30 years of doing ICWA cases, a lot of those cases are unnecessary. A lot of those cases are children who have been removed from their parents on pretext. So are there a lot of cases out there? Without question. Does the state perhaps remove Indian children at a higher rate than they do any other group? Without question. So the tribes are going to have to deal with that. And we'll have to see exactly how bad it is. Now, I've worked in tribal courts all over the state of Oklahoma. I've done it for 30 years. And I know without question that given the resources, the tribal courts are entirely capable of handling Indian children. They are entirely capable of working their cases. And I'll just be honest, it is gut-wrenching to see the tribes want to leave children in state custody. We are not a great state when it comes to the way we treat our children. And we, if the tribes can keep their kids out of that system, then the tribes need to do that. So, that's that of course is my opinion. I'm sure there are many people who would disagree.
I might also add something maybe more positive as it relates to a bandwidth conversation outside of the scope of Indian child welfare, but really looking at those law enforcement cross-deputization agreements that Arvo was mentioning. When we think in terms of those cross-dep agreements, what we really have seen are tribes who are able to provide resources that their local law enforcement counterparts don't have. And tribes also have access to some additional funding mechanisms that are federally funded specific to law enforcement needs in Indian country. And those benefit all of the cross-dep partners. So when we talk about bandwidth, there's some give and take to be had on both sides in different areas, but it's not always the tribe in the position of needing to receive additional bandwidth. A lot of times the tribe's the one providing the additional bandwidth.
The other thing to keep in mind too is, and this is kind of more in the criminal context, but the concept applies just as well, is the fact that, you know, we don't necessarily need sometimes more people. I mean, again, the number of child welfare cases are the same. The number of crimes are the same. It's just a matter of who's handling them. For example, we have what are called SAUSAs, S-A-U-S-A. I'm an assistant U.S. attorney. A SAUSA is a special assistant U.S. attorney, and we can basically cross-deputize a state district attorney to come into federal court to handle crimes. We can do the same thing with a tribal prosecutor to bring them in to allow them to handle certain crimes in federal court. We, for example, use JAG officers from the Air Force bases, and they are also SAUSAs. There's a whole docket of cases for misdemeanors that come from Tinker Air Force Base, Wichita Mountains Wildlife Refuge, Fort Sill, Vance Air Force Base. So there's things that really, you know, can be done. You can cross-deputize a prosecutor. You could maybe, you know, if it's permissible under tribal law, why couldn't you have a state prosecutor come into tribal court if they've been working with that case, or vice versa? Now, if there's any legal impediments that are in place, you know, maybe it's a time to think about, okay, well, we can wear multiple hats, and that's, we've done that with police. We've done that with the police. You can wear multiple hats. You respond to the crime. Okay, I've got a tribal hat, a federal hat, a state hat. So I'm covered. I can investigate whoever for whatever, and then we investigate it, we figure out what happens, and then we send it to the right courthouse. You can do the same thing, not just with the police, but with you know, cooperative agreements about probation officers, cooperative agreements about, you know, tribal prosecutors. So, you know, we just really need to think about what we can do, and we don't have to, you know, put up a Chinese wall between each other and then throw up our arms because we don't have enough people now on this side of the wall. We've got more work over here, where now the state's going to have less work.
Thank you all. We have an attendee asked a question that was interested to know whether any state prosecutor or state law enforcement agency on the ground are arresting and prosecuting under Oklahoma AG's newly mentioned argument that there is concurrent jurisdiction in General Crimes Act cases.
Not that I'm aware of, not yet.
Great. Are there crimes beyond domestic violence where tribes can prosecute non-Indians for crimes committed within the reservation boundaries?
Short answer to that is no at this point in time. That special domestic violence jurisdiction is basically what a tribe can prosecute against a non-Indian. Now, I know some tribes, some locations have what are considered to be kind of civil remedies and things like that, but you cannot prosecute somebody and put them in jail, a non-Indian, unless it falls within that narrow category.
I might add that when I talk about kind of the opportunities for improving the landscape of Indian law that we've all had to deal with for our careers, that special domestic violence prosecution authorization that undoes Oliphant for purposes of domestic violence prosecutions is really a recognition by Congress that tribal courts are entirely capable to do these things. And I think that's a step in the positive direction. And hopefully there's more to come insofar as restoring tribal courts' authority over non-Indian offenders. It seems to be working well in the area of domestic violence, and that demonstrated skill and capability should go a long way towards undoing Oliphant in a more broad sense.
Thank you, Casey and Arvo. Tribal governments exercise powers of self-government, including business councils, and many have tribal courts with law enforcement. Does it remain an open question whether federal jurisdiction is exclusive of tribal jurisdiction?
I would say generally it's not. You know, the tribe, at least over Indians in the criminal context, has essentially full authority to develop any criminal offenses, absent those that, you know, Congress has come in and taken away their ability to do so. And insofar as I'm aware, that's never happened with any tribe in Oklahoma, with the exception that we already discussed about crimes over non-Indians.
Thank you. Since it is generally accepted that the definition of Indian country under the Major Crimes Act also applies to civil law, why do you think Justice Gorsuch's opinion appears to attempt to limit the decision only to cases of criminal jurisdiction?
Well, I don't know why he did that, but that's what was before the court. Generally, a court is not going to go beyond what the issue it is that they have to decide, and that was the issue there. You know, some people have said, I've heard, well, does it just apply to the Major Crimes Act? And that's not true. What the question was, what is Indian country? And when does Indian country, in the context of 1151A, when does that cease? When does that boundary get erased? And it's been a difficult question for the courts. You look at the opinions, and again, unless it's clear, like with the Otos or the Poncas, that's a clear, you know, everybody knows that the reservation boundary was erased. You know, I looked at the Irby decision, which involved the Osage Nation, and I'll just read a little excerpt from that. And this was a 10th Circuit case. It was whether or not the Osage reservation boundaries are still there. And I think most Indian attorneys and most people looking at the question of whether or not there were reservation boundaries would probably say that, you know, probably the Osage had the strongest argument. The 10th Circuit decided differently, and this was back in before McGirt, obviously. But the 10th Circuit looked at the Osages, and in determining whether or not the Osage Allotment Act somehow erased the boundaries, what the court did, and this is interesting because the court looked at this book, and I just happened to have this book on my shelf, and quoted from Francis Paul Prucha, this book, and said, this is what the book said: in preparation for Oklahoma statehood, the Dawes Commission implemented an allotment process for the 5 civilized tribes that extinguished national and tribal title to lands and disestablished the Creek and other Oklahoma reservations. Okay, so you have the 10th Circuit here in this case, you know, relying upon a book or an author rather than, well, I mean, they relied on other things as well. But again, this author is being quoted in a 10th Circuit case, and because he said the boundaries were erased, the Creek Nation is gone, and this was in 2010. This was not all that long ago. So again, if part of the problem that we've had, and those of you who've been around a long time like I have, will remember an article written by Browning, Pipestem, and Bill Rice called The Mythology of the Oklahoma Indians. And it's based on assumptions. And I had a very influential attorney that I used to work with at Andrews Davis, and he had a little sign up in his office, and I want to get one made sometime, but it says, "Assumption is the mother of all screw-ups." And that's what's happened over time. Everyone has assumed certain things, assumed the boundaries are erased, assumed the tribes didn't have power, assumed that the eastern tribes were different from the western tribes. And so after Little Chief, when the tribal courts were reestablished, they weren't reestablished for the 5 tribes. Well, you know, you might say, well, the Curtis Act is responsible for that, or in the Curtis Act doesn't even necessarily fully apply to all of the tribes. But why didn't the Osage get their courts reestablished? Why didn't the Northeast state? They're not 5 tribes. They weren't subject to those unusual laws. And again, it's this assumption. So whenever we look at these disestablishment cases, it's going to be very important to look at the underlying facts. Like I said, for example, in the Dakota case, which is the first case that has certain language in it, a lot of congressional intent was hinged upon what some reporter wrote in the newspaper, quoting a tribal chief in 1890 something or other. In the Osage case, they were quoting one tribal chief again, and then this author. So it's going to be very important to look at each instance. Did the tribe agree? Was the tribe opposed to it? How was the reservation opened up? Now, everybody knows, you look at the population figures, just for our own tribe, most of the tribes, the lowest point of population is right around the time of allotment. Because of why? Well, warfare with the United States, pandemics, loss of land, destruction of the buffalo, all kinds of things. So if you apply this population formula, how many Indians compared to non-Indians were there? The tribes always are going to be a lot fewer people. So how does that relate to congressional intent about erasing a boundary line? I did some work down in East Texas when I was a law clerk for a federal judge, Judge Parker down there, and it involved the red-cockaded woodpecker, which was an endangered species. And I got the map of the Sabine National Forest, the Davy Crockett National Forest, and I looked at it, and it had a boundary around it. But then you looked at what the land was, the forest land, it was like 20 or 30%. Most of the property in the national forest isn't even national forest land. It's owned by private landowners. So this is not something unusual just to Indian country. Again, practitioners out there, if you're filing things, if you're making these arguments, you really need to consult with somebody who's familiar with Indian law, because it's almost reckless and committing, well, you're not serving your client well if you don't do the research, is what I'm getting to.
Arvo, I just add that the Oneida decision that just came out of the Seventh Circuit was not a criminal case. It was an issue of sort of a regulatory issue. The Seventh Circuit obviously looked at the decision and said that it had a much broader impact than just major crimes.
Well, thank you, panelists. I appreciate it. And thank you, attendees, for all your wonderful questions. At this time, I will go back to Stephanie Hudson.
Thank you, Case. First of all, I'd like to thank Case Rodwell and Brian Candelaria. They are both attorneys at Oklahoma Indian Legal Services, and their services were invaluable today in assisting us with putting on the webinar. So thank you very much to both of you. We really do appreciate your help.